The Democratic Alliance, Action SA and AfriForum say that they will be challenging the Land Expropriation Act, which has been signed into law by the President. The DA says the discussions are being held with lawyers to formulate a case. Action SA believes that the previous legislation was adequate to deal with the land reform, while AfriForum claims it's ready to protect property owners if their land is taken without compensation. Meanwhile, the Deputy Minister of Public Works and Infrastructure, Sihle Zikalala, has welcomed the signing into law of the Expropriation Act, describing it as a seminal and groundbreaking law. And he joins us now to have that conversation. Deputy Minister, very good morning to you. Thank you so much for making time for us. I want to quickly just deal with the politics and get the politics out of the way, and then we'll deal with the act. You were previously the Minister of Public Works, also worked on the bill that was before Parliament and later on the National Council of Provinces. Being part of the Government of National Unity and having the likes of the Democratic Alliance part of it, the ministerial principal in that department is Dean McPherson, who is also from the Democratic Alliance. As South Africans, how should we understand where the department stands on this decision by the President to sign the law, to sign the bill into law?
Well, firstly, we must acknowledge that any bill or any act come from the realization of the need, and then it is started by Parliament. It goes through to the to the NCOP, the consultation process, and then come back to NCOP and Parliament. And then it goes to the President, who then signs. And therefore, this should be accepted as the expression of the people of South Africa, and they have expressed themselves and their will. And therefore, the DA, the Action SA, and all parties must come to terms that democracy in South Africa is working.
Yeah, would this apply to the minister as well? And I'm asking this on the basis of, if the Democratic Alliance says that they are looking to challenge this in court, and perhaps maybe the department would be cited as the implementing agency, as one of the respondents, who signs off on the affidavit? What is even said in that affidavit by the department?
I'm hopeful that the minister considered this act before President assent it. And I'm hopeful that he will sign if the DA goes to court. But this now, if it is challenged in court, it challenged the decision of the government of South Africa, and therefore the cabinet will have to respond to that.
Yeah, and would the minister then have to follow whatever cabinet says, irrespective of whether the political party that he comes from is against that particular... I
would not want to speak for the minister. I think
sure, I'm just saying in terms of the rules, because the rules are in place.
No, he can speak for himself on that, but the president, as he has signed this into an act, he has a right to defend it. And therefore, it will be defended if anyone take it to court.
Okay, so here's the point that is raised as well by the Democratic Alliance. They say that the process that was followed in the NCOP was flawed. The Northwest didn't have a mandate. KwaZulu-Natal, the Free State and Mpumalanga, as well as, KwaZulu-Natal as well as in Mpumalanga, that there were issues there, that they are not the majority. So therefore, that process through the NCOP was flawed. What's Deputy Minister's understanding? But at the time you were Minister of that department, what's your understanding of that process that was followed?
In the NCOP, all provinces are given opportunity to express themselves. If a province says we are not expressing any view, that is also accepted. But the NCOP can't wait for a province that is not deciding It has a time frame, and therefore what is said is also flawed because that argument doesn't hold water. And the NCOP had a majority, and it proceeded on the basis of the provinces that had expressed themselves.
Okay. Then let's deal with what the bill seeks to do. And the question that people have raised is how different is this legislation to the 1975 legislation, considering that we already know that there is an option of expropriation without compensation, the argument that had been made even before, that the Constitution had already empowered the state to do so.
Well, there's been a number of cases where the state have tried to expropriate, but people have taken the state to court and compelled the state to pay for expropriation, hence a need for this act. And now we are sure and guaranteed that this is an act that has been promulgated and signed by the president. It will then help us. Yes, it is not a change of the Constitution as expected before, but it gives mandate to the state to expropriate in the public interest. And therefore, it will be better than that act of 1975.
Yeah, how do we define public interest? Because this is an argument that has been made before as well, that we remember even with the expropriation of land, specifically with the building of Gautrain, but in that particular case, there was compensation. So how do we define public interest where there is no compensation?
Well, firstly, as you refer, for servitude and other need of state and state organs, it will mean that we don't pay. It will be expropriation without or with nil compensation. But if also it goes to the question of protection of the communities or advancement of the interest of communities, that will then enable us to expropriate without compensation.
Can you give us an example of a possible scenario where you could have no compensation for expropriation based on public interest?
Let me take one scenario. A scenario will be like you had a building that is dilapidated or it is not used. It poses a threat to communities around the city or around that vicinity. And then the state, if it comes to terms that these can be expropriated to be under government, destroyed so that it does not pose a threat to communities, that will be done.
But already that there is legislation that allows for that. Is that not true,
No,
Deputy Minister?
It's not true. Remember that we have recently held the fire that affected communities in Johannesburg. It comes from that situation. But also, there are a number of land parcels that could help communities. But those land parcels can't be expropriated because of the fact that individuals don't want that. There are a number of people who are evicted from where they are residing, and this act could help us to address that situation.
Yeah, I'm just thinking now, Deputy Minister, and you'll clarify this for me. An example is with the West Point Lodge in eThekwini, that the municipality has decided that it would be taking over. Was that not a form of expropriation?
It was a form of expropriation.
So it seems that there is already legislation that allows for that.
Now you are bringing one case where the city says we are taking over and the owner is not contesting that. Mm-hmm. In most cases, when there are such buildings, you will find that the owners will contest that, and then it becomes a problem. Hence, the Act now will empower us to expropriate whether the owners like it or not.
Yeah. But again, the legislation says the owner can still challenge that, and the onus will then be on government to take the matter to court.
Yes, we take it to court, but at the end, we are empowered by this act, and that must be noted. The very same city of eThekwini tries to expropriate some land along Umgeni and then Umgeni River. They couldn't because they were told that the owner wants some compensation, and that was in the public interest, and it couldn't go ahead with that. But with this act now, they are empowered, they could do so.
Yeah. Another point that is raised by Mkhonto Wesizwe as an example, and you made the point that the Constitution hasn't changed, it remains the same. There was a process to amend Section 25 of the Constitution. But currently as it stands, even if government was to expropriate with the public interest, even if it is for the purposes of restitution, it can't do so beyond the date of, or the days before the 19th of June 1913, which was an issue that the ANC had raised before as well. So how do we deal with the dispossession that was done before 1913?
Well, that's an issue that must be debated in Parliament. It should be noted that we tried as the ANC to change the Constitution, but other parties demanded a number of things, hence the ANC proceeded and that act could not be passed. And therefore, if there is such a need, we must work together to ensure that there is 2/3 majority to pass that act.
Yeah. Yesterday, my colleague was speaking to Mzwandile Masina, NEC member, and he says that maybe there should be the discussion around the amendment of Section 25 of the Constitution. There was a resolution by the ANC's conference to have the section amended. Do you think that there's a possibility to restart that particular process?
Definitely, there is a possibility. The engagement at this level of party cooperation is on issue by issue, and therefore this matter could also be engaged, and if possible, it could be advanced into the act.
Okay, thank you so much for your time. Sihle Zikalala is the Deputy Minister for Public Works and Infrastructure.